we could make the screen just that witness, then so we could see facial expressions, but having the 3 different screens or 4 different screens, we can't really see them even on the screen. That's a suggestion. I don't have anything that must be lost, so
You're looking at
oh, yeah. Well, I was walking down the hall yesterday. Andrew got a lead at the green church. He said, "This is Miss Crabtree, welcome to church." And I'm like, "Hi," and we're walking. Somebody simply said, "Well, that's advertising." I'm thinking, "She probably kissed me." I'm going, "It's over." There is no security.
well, like I said, that's good. I walked in and I thought,
Yeah, I was pretty good. Because the other side, no, the other side, not kids.
I didn't think so.
They said they.
That's probably.
She said she was wrong.
Thank you for protecting us.
I'm waiting for on Rosa, they're not in it. Are you still using it? Because I sent you an email asking you, because we did that agreement. And I sent you an email asking you. Okay. So.
You think we'll be okay with that?
It's been a while.
I know we settled it and you said that you were gonna talk to him about whether he was gonna file a new petition.
He is, but he thinks that what he wants is limited. He thinks she might have merged. No, but I just didn't want to send something to her without telling you first.
It's the Gmail, right?
Yeah.
Last thing I got on Roper versus Bruce was the order from Peggy. I got you on 6/10. I got an email from you that said that it was like, okay, thanks for letting us know. Have a great day. And that was from
Okay.
That was from the shape.
So can we get dates and send them to you?
Yeah, I still represent her.
Okay, good. We'll get that done. Yeah, because it's really minimal. He's not asking for huge.
Yeah, but like I said, I don't check and make sure that it.
He said he learned a lot of lessons from that.
And again, I'm sure he's. Yes. And she refused to in the business. And it was.
You need it sometimes the tabs make sure the QR.
I'm glad to see her.
Well, I'm like, she's got.
But, yeah, well, she knows.
Tell them those paper tablets.
Yes.
Those things are awesome.
So,
Yeah, hey, everybody's gonna have their own.
Yeah, I like this because I can keep my notes and
That's it.
it makes it so much easier.
You have.
I have hers, but I don't.
He's with this new.
Yeah,
Who I think is.
Instead of concerns.
That's what I'm saying.
We'll see what we can do with it.
But again, if she's good to get, who cares?
We'll get you dates and see if we can get that one done.
Yeah.
See ya.
Eating help. I was trying to say.
Yes, ma'am. White lady.
Yeah.
Law offices up.
Yeah, so you can wait for it, but
Okay.
okay. Just in case, because I know everybody.
Is your dad?
He did. He did.
I'm sorry.
I'm not.
You never know how to respond.
Nope.
Email?
Kendall, KENDALL at ATTY, KendallWhite.com. No problem. You need a cell phone number?
I'll need a phone number.
Okay. I like to say it.
Marty Cook. Call me Marty.
Marty,
Yes.
the way to go.
The way.
The rumors of my death is breaking exactly.
Relax.
I was just talking to the deputy about the Jersey bagels that I've been No, those are important life matters. Good bagels can change your life. That's what a day in court can do.
And this gentleman is a lawyer. At the highest.
Strike me dress for the weather.
You believe you'll have.
I didn't break my hand today.
I'll do anywhere without.
That's just something.
Are you still on Woodland?
I am. Yeah.
My deli
Reception. White seniors retired. Okay. And her juniors are still there, so you say mine. And I have to work.
There's never too many Mondellis, right?
All rise. Chancery Court of Cheatham County is now in session. Honorable Judge David Wolford, God bless the courtroom, grace to the Tennessee, God bless the United States. Please be seated.
Hi, good morning. We'll start with a call on the docket.
Case number 4224, Martin.
Good morning.
Well, good morning. I show Deborah Moore as your attorney.
Yes, sir.
Have you heard from her? We haven't seen her yet.
I've seen her in the hallway, but I haven't spoken with her.
Okay. Well, if you see her, round her up and bring her in here. Okay.
Do you? That's
All right,
okay.
we'll come back to you after she's in.
Thank you.
Go ahead and call the next case.
Case number 4178, minus Patricia Davis.
Good morning.
Good morning, Your Honor. Attorney John Evans on behalf of Mr. Paul Rutherford. I think he has a motion for fees. He said it was uncontested. He was unable to make it today, but asked if I could stand in for him.
All right. And there's no contest. There's no objection to his request for fees. Is that correct?
That's what he notified me yesterday, Judge. And I'm aware of
Anyone
it.
here in the matter of Gladys Patricia Davis? I have reviewed it. It does seem to be reasonable, so I will approve it. So,
Thank
you. You have an order?
He didn't provide me one, Judge. I'm sure he'll
Just tell
follow.
him to submit an order, please.
Thank you, Judge.
Case number 4180, Jerry W. Binkley.
Good morning, Your Honor. Marty Cooperman on behalf of Binkley Estate. And I was apparently Mr. Rutherford's second call.
You were the backup? Is that what you're saying?
I was.
All right, this is an exception to the claim of Centennial Medical Center. Anyone here to prosecute the claim of Centennial Medical Center? All right, and also an exception to the claim of North Crest Medical Center. Anyone here to prosecute the claim of North Crest Medical Center? No one here to prosecute those claims. Your exceptions are granted.
Thank you, Your Honor. And I have a couple of orders.
All right.
And making me feel old, another new courtroom in Middle Tennessee that I've outlived the life of the other ones. I guess that's a
Well,
good thing.
we'll be using the old courtroom still, but this one is a kind of a trial run. See how we're going to see whether we're going to be able to accommodate a jury trial in here or not. There are a lot of glitches we got to get through before we can finalize.
And they'll always be better if they consult the people that work in the building when they build.
All right, thank you.
Thank you, Judge. Good to see you.
Sorry. Call the next case.
Case number 18172, Amber Brazel versus Timothy Adcock.
I know Miss Bailiff is on medical leave. She has an associate that's supposed to stand in for her, Miss Dreiser. I haven't met her yet. I had a brief email exchange with her yesterday, Judge. She may be
Well,
trying.
let's see if you have a number to call. You might call and see.
I know I got a little lost this morning myself coming to the new courtroom.
Well,
so
and they may be wandering around the hallway outside.
I'll go check, Judge.
We'll put it on second call.
Thank you.
Case number 17291, Philip Brown versus Shelby Myers.
I'm showing the attorneys are Marissa Knight for Philip Crandall Brown, and of course you, Miss Squires, correct?
Yes, Your Honor.
Well, Judge Turnbow set this matter for today under an order that was entered on June 16th, but from a hearing on June 5th. So Ms. Knight was made aware of that Have you heard from Miss Knight?
I'm sorry.
That's
No,
all right.
I've not heard from her. I did have a Zoom call with my daughters yesterday, and actually, I believe the date was tomorrow, and I found out over the Zoom call that it was today, so I drove up to make sure I was present for it. So the father was aware.
Well, at this point, we don't have the attorney representing Mr. Brown, who has filed an answer on his behalf to your petition to relocate. I'm going to pass it on the docket this morning until we can determine where Miss Knight is and why she is not here. So just have a seat. We'll come back to you on the second call.
Thank you.
Case number P3698, Dan Murphy Elliott.
Good morning.
Good morning.
So, Your Honor, good morning. So,
We're here on a status. We're here on a couple of matters, Your Honor. It's probably going to take a little while. Nothing that
That's
can be covered in 5 or 10
Well,
minutes.
nobody else seems ready to proceed, so we'll take you up.
okay. So, Your Honor, Andrew Triplett with the Sumner County Bar, representing Virginia Williams individually. Mr. Dwayne DeVault's present as counsel of record for the estate. Ms. Shannon Emick is present counsel for the petitioners, which is a group of the heirs, David, Stephen, and Jamie Michelle Denton, and the Elliots. And this is a status conference on the estate. However, there are several motions that were set for hearing today. I'd like to give some context. This centers around the court's order in this matter that was entered on April 15th, based upon rulings from the last hearing on this matter on March the 3rd. And on May the 14th, Ms. Williams and the estate both jointly filed several motions, specifically a Rule 5904 motion to alter or amend this court's order based on the grounds of the application of the rules regarding Rule 3601 of Civil Procedure, specifically regarding requests for admissions that were submitted to the Elliots, the petitioners, that were not timely responded to pursuant to an agreed scheduling order that was executed on November 20th of 2025. So for that basis, Ms. Williams and the estate are requesting that this court alter or amend its judgment, granting a good cause for a 10-day extension for the petitioner's late responses to those discovery requests. It is the respondent's position that there was insufficient good cause. Alternatively, the Ms. Williams and the estate have also jointly filed a motion for an interlocutory appeal on that limited basis under Rule 9 of Appellate Procedure for a limited issue of whether the petitioners failed to answer respondents' request for admission within the time provided and whether or not this court had the discretion to grant that extension. Additionally, we've also filed a joint motion to stay the estate proceedings and the proceedings on the petition to remove the administrator under Tennessee Rule 62 of Civil Procedure. This court has the discretion under Rule 6201, 6207, and 6209 to make that discretion and stay all of the proceedings and all these deadlines. It is the respondent's position that the motions that were jointly filed stayed and told the applicable deadlines and the finality of this court's order that was entered April 15th. Those motions were jointly filed on May the 14th. This court's order from April 15th had a deadline of completing all written discovery and all discovery by June 30th, 2026. It is the respondent and the estate's position that those deadlines are not binding or final yet, pending the court's ruling on these joint motions. Now, the petitioners have not provided a timely response to the joint motions. I believe they filed a late, untimely response yesterday, raising concerns about the respondents' arguments and based on the law that was cited. But it is the respondent's position it has the court does have some discretion in staying these proceedings, but it's the respondent's position that this court does not have the discretion to grant the 10-day extension of those deadlines under an agreed scheduling order that was willingly signed by counsel for the petitioners that agreed these deadlines that were passed and not complied with. Rule 36.02 of civil procedure uses the phrase conclusively established. When admissions are deemed admitted in a civil action, it is conclusively established of those admissions into the record for purposes of trial, unless by motion the party requests withdrawal or amendment of those responses. That was not timely done before that deadline passed. It was filed after, filed late. And also an expedited motion with a request for a 2604 protective order and a compilation of other motions. I'll defer to Mr. DeVault regarding the concerns that the estate has about this matter.
Your Honor, may it please the court, Dwayne DeVault of Nashville and Sumner County Bar. We ratify and reaffirm everything that the statement for Mr. Triplett has made to the court representations. We're here on 3 motions. I would refresh the recollection of the court that we entered into a scheduling order pursuant to the instructions of Your Honor on the November 5th hearing. And we complied with that. We propounded written discovery, excuse me, to include requests for admissions, requests for production of documents, and written interrogatories. I hand-delivered all those documents to the Elliott's Council on Friday, December the 4th, thereby leaving them, pursuant to the rules of civil procedure, 30 days to comply with not only the rules of civil procedure, but the order of this court, that all written discovery be completed by January 5th. During the month of November and December, I went to my post office box almost every day except for Thanksgiving and Christmas and Sundays, expecting written discovery from the Elliots. None was propounded until after the deadline. Ms. Emick provided a notice for a deposition of Ms. Williams. We objected to that notice because she did not include all of the parties. She did not notice any of the Murphys, who are in the same position, beneficiaries of half the estate as the Elliots are. We filed 2 other objections to the deposition. They were remaining with the court, and we preferred those to the court at a previous hearing. And then we scheduled a deposition for the Elliots on February the 4th. We were all present, Mr. Triplett and I, at Cobb Law in Hendersonville at 10 o'clock, ready to commence the depositions. We sat there 10:15, 10:30, 10:45. Mr. Triplett sent Ms. Emick an email saying, "Where are you? Are you coming to the deposition?" She responded, "My clients aren't available, and why do you think you can depose the Elliots?" We have complied with this court's order, the rules of civil procedure, and here we are 8 months and 3 days later, and we don't have one single document in response from our request for production of documents to the Elliots, which again I hand-delivered to their counsel on Friday, December the 4th. Your Honor, we object to the late filing of a response to our 3 motions. We object to this court allowing Ms. Emick to respond in opposition, and we recommend and suggest that this court should grant our motions. Thank you, Your Honor.
Good morning, Your Honor. Of course, we're going to ask the court to deny all their motions. We're also going to ask this court to require a bond if Ms. Virginia Williams is allowed to continue as personal representative. And here's our reasoning. We have been trying to get financial documents since July of 2023. We've made over a dozen requests for those. My last email to Dwayne DeVault was, maybe please have the accounting so we can close up this estate. Delay after delay, a dozen requests, and Your Honor denied my request for subpoenas and stated that we need to go through discovery. that was at the November 5th hearing. And so your order quotes that the motion or the discovery shall be due within 30 days, or just like the rule says, or within a time that the judge allows with discretion after hearing the facts or the reasoning behind the delay. I contacted you and ran your court assistant down trying to get in front of the court, but to get that extension. But unfortunately, the way the judges rotate, I wasn't able to get in front of you. The hard thing about this is that the opposing party didn't follow the local rules, and it's baffling to me because I did everything I could to notify them that I was going to be a little late because of the holidays, and good faith said I needed a few more days just to get the notarization. And instead of conferring like the local rule, I think 6.03, I believe, states that we are to confer before filing anything with this court, they filed the motion to deem admitted a day before I said that I would have the responses. And now what they are arguing is that this court doesn't have the ability or to act within its discretion to extend that time. They are quoting a law that is not, or they're quoting language from a law that, or a case law that does not exist, Your Honor. I spent hours trying to find where these cases that they quoted stated that it was mandatory. And the only thing, and I've got a copy of the cases that I can put together. I've got a couple of copies. States nowhere that it is mandatory to deem it admitted. It is a civil conspiracy case. There's a fraudulent case that they quote, and the only reasoning I can think of is it's possibly AI generated, being that I have a lot of experience with AI myself. It is a way to get this argument in front of the court without real case authority. And as far as the motion to alter amend, it states that the court committed a manifest error by not deeming the omissions, and that this court did not have the authority or the discretion to extend it. I argue that this is just another delay tactic. What we do know is that there was never conservatorship or estate bank accounts opened until maybe recently, maybe a year ago. We do know that all of the funds from the conservatorship and the estate ran through an account with Virginia Williams' names on it. We do know that there's over $600,000 missing from the conservatorship to today. And we do know that we can prove the damages if we are allowed to get the financial documents. But it just appears that whatever we do, whatever we come to this court on, they're going to find a way to dodge it. And Your Honor, we're asking that we just move forward with mediation, that the requests for documents that I sent to them were requests that for those financial records that my clients are entitled to. It's their inheritance. They should know what's going on with it. The interesting thing too, Your Honor, is that we propounded our requests for documentation back in January, and they never provided them. I sent a good faith letter to confer about what's the status before I filed my motion to compel, and they're silent. They use the court to try and delay and get this court to punish us when they're not following the rules themselves. And so, Your Honor, we are asking that we can just move forward. If the court asks them to produce the documents that we've requested, then give a strict timeline. If not, let us move forward with subpoenas. We want to just get this matter open and set a final hearing for today, set a final hearing, deny these motions, and set that final hearing so we can put this to rest. the request that they made to us, and I explained it, and I even quoted the law, is that documents that are readily available in the court or in public record, we are not required to produce those. Every answer that I submitted to them was, this is an exhibit A through N, or exhibit here that was filed on this date. It's in the court's record. They're claiming that we didn't produce the documents, but they were readily available in the court. Also, the documents that they're requesting from us are all the documents that they provided to the court. And so it's just another way to stall, delay, keep this thing moving when we've got a 3-4-year-old case that's been open. We know that things have been done, and we want the final answer and the final number of what those damages are. So we ask that, lastly, Your Honor, that we, like I said, just require mediation and just set a date for the final hearing.
So you want mediation, or you want to set a final hearing?
Well, we can't really, I mean, I know it's the laws, the local rules.
I've handled this case for a couple of years now. With all due respect to the fine attorneys on both sides, I don't think mediation is going to result in any kind of an agreement.
That's fair, Your Honor. I didn't know you had ordered it in your last order.
Yeah, well, it's optimism on my part that I think is unwarranted. So
we just need the financials that we're requesting before we can have a final hearing.
Mr. Duvall, our co-counsel has indicated that there were documents or some discovery that you had not supplied to them. Are those the documents you're saying that you refer to that are available in public record?
Yes, Your Honor.
And what specifically are those?
The documents about the conservatorship, the numbers that are quoted in the conservatorship accounting. I'd have to look at all of it, but each of the questions, or they were asking for documents that my client didn't have. Their questions or their requests are trying to prove that my client, Jamie Denton, was part of all this. And their own client stated under oath that she absolutely did not allow Jamie Denton to see records, didn't provide the records.
But wouldn't it be a simple situation to say, we don't possess those records? In the answer
I did in some of the answers, Your Honor. In the questions where they asked about our note or my client's notes or accountings or anything, I did state that we do not possess those.
I interrupted you. Is that all you had to say?
That's pretty much it, Your Honor. That just we're requesting that this court deny their motions. I have a motion to compel, which was done after I requested under, like the local rules requires, motion to compel the documents that we requested back in January. And that, Your Honor, their argument that their motions stay any discovery, that just deny that argument as well, Your Honor. And set a bond, please.
Your Honor, if I may respond briefly. I appreciate Ms. Emick bringing up her motion to compel, because that motion to compel was filed on July 1st. It was filed on July 1st because it's based upon this court's June 30th deadline, based on the order that was entered April 15th that has not become final yet. That is the whole purpose of the 3 motions that are pending before this court, is asking the court for motion to alter or amend that exact order that has not become final, because based on the pattern of issues throughout the discovery process, the lack of compliance with the original agreed upon scheduling order created all of these issues. Now, if there was a motion to compel in January, or if we could reach an agreement about 10 days extension, or if there was sufficient good cause for delays in producing discovery, we probably would not be here today. But it is a consistent pattern of no production, late written responses, outright refusal to appear to depositions. That was the whole premise of a joint motion for sanctions being filed. This court has described this case, unfortunately, as a contentious and acrimonious case. Nobody wants it to be in that situation, but that is where we are. And there's not a motion asking this court to set a bond on this matter. It's only the motion to compel based on a deadline that is not final. It is not enforceable yet. That was what these three motions are here about. So we reassert our position that the Rule 3602 language specifically requires admissions to be deemed admitted, and that is conclusively established unless by motion requested withdrawal or amendment of those admissions properly by the non-responding party. And that was not timely or properly done. That is the respondent in the estate's position. That is the basis of the Rule 59 motion. That's the basis of the Rule 9 motion for interlocutory appeal on that order. Now, Ms. Emick has hinted of trying to prevent any undue injustice to her clients, the petitioners, the Elliots. The respondent takes that same position. That's a grounds for Rule 5904 to prevent any injustice by any party, including Ms. Williams and including the estate. And there's these issues about delays. Nobody wants this case to be delayed. This court wants this estate to be properly administered. The estate has filed at least 2 motions to disperse or distribute funds. There's over $500,000 lodged with the court as of today that's accruing interest daily. Everybody can all agree, I think it's the only thing we can agree on, that everybody wants this estate administered and resolved. But the respondent and the estate jointly agree with this court that we do not see mediation as fruitful despite these circumstances. But we request that this court reconsider and alter or amend its judgment based on the lack of good cause of the pattern of behavior throughout the discovery process by the petitioners. I defer the rest of my time to Mr. Duvall.
Your Honor, please, for judicial economy, I will refrain from reiterating any of our positions. I apologize, Your Honor. For judicial economy, I think Mr. Triplett has adequately stated our position. Ms. Emick referenced a dozen requests. That's not true, Your Honor. My computer does not show a dozen emails from Ms. Emick in the 3 or 4 years of the pendency of this matter. She has filed matters late. She has reworked. She has continually made allegations, but they have little to no proof. They did not file a petition to remove Ms. Williams as the executrix of the decedent's husband when Ms. Williams executed a deed to $1 million piece of property that they inherited through Carney Elliott. They didn't object to that, Your Honor. But they made repeated allegations defaming this lady, and we submit.
I've not heard that before. Is that some new piece of evidence that you had yet to be?
Well, Your Honor, the court can look back at the estate of Carney Elliott, and Ms. Williams executed a deed of trust for the Elliott Family Farm Trust, valued at $2 million conservatively, and Ms. Williams executed that deed and delivered it to the Elliots in the estate of Carney Elliott, and we closed that estate. So they didn't complain of anything when they got $1 million piece of property. Respectfully, Your Honor. Thank you.
Your Honor, I'll just say that was a will, and that Carney Elliott left.
Oh, I'm going to deal with one estate at a time.
Yes, Your Honor. I just asked that. I could go back and forth too, Your Honor. I think at the end of the day, we need to move forward. We need to finalize this. We need financial documents to show what the damages are, and we're ready to move forward with that, Your Honor. Setting a final date.
When I first considered the motion to deem the request for admissions to be admitted, and we had that hearing back in March of this year, I considered the entirety of this case, including all of the hearings that we've had before, the general attitude and what has taken place in the courtroom on many occasions, and the general anger and hostility that exists, it seems, between these parties. And I'm in my order on that, following that hearing, made several findings. One of them was that this was a case involving a contentious and acrimonious estate litigation. I went through and cited all of the background of it and the petition to remove Virginia Williams and the allegations that she had made certain changes to the while acting as a conservator for Anne Murphy Elliott, that she had unilaterally altered the beneficiary designation of annuities held by Tennessee farmers. I mean, these are allegations that were made. They've not been proven, but they were allegations that were made. The petition that was to remove Ms. Williams also made the allegations of misconduct or mismanagement of the estate and sought to prevent the unjust closure. Those are very serious allegations. As Emmett has repeated, there is alleged to be some $600,000 missing from the estate. As a result of that, I tried to move it forward by putting forth a scheduling order. And as Mr. DeVault says, they did comply with that order by tendering certain information and requests for admission, including as well as as well as discovery requests, interrogatories, and so forth. The problem that I had with it then, and I still have it, is that as was shown to me at the hearing, the respondents in this case are seeking the strict enforcement of the Rule 36 by saying that because they were late in answering the request for admissions, that it should be mandatory that the request be deemed to be admitted. And they've made that argument today again. I have looked at the law in that particular situation. I did considerable research on it. And, you know, the evidence at that hearing was that the petitioners have requested additional 10 days to provide the answers to the discovery. It's also important to keep in mind that I think this ran during the holidays, and that I made a finding that it was understandable that the petitioner's counsel would probably have difficulty in getting the answers, and requesting an additional 10 days was reasonable under those circumstances. I found that there was a basis for an enlargement of the time, and that the granting of the request to deem the request for admission to be admitted was extremely punitive and was not warranted under the circumstances. I went on to cite the rules as well as the Court of Appeals decisions. For example, in the Tennessee Court of Appeals decision of Meyer Laminates Incorporated versus Primavera Distributing Incorporated, I quoted the language from the Court of Appeals that said, "We are of the opinion that the clear language of Tennessee Rule Civil Procedure Rule 36 provides that the trial court discretion to allow withdrawal or amendment of matters deemed admitted because of a party's failure to timely provide answers to a request for admission, including when no response has been provided by a party who has received a request for admission." You know, this case raises allegations that haven't been proven involving potential violation of a fiduciary duty of a conservatorship and an estate. And while this, you know, the respondent is adamant that those are false, it does seem to me that it is the type of situation that this court wants to have the hearing on the merits rather than on a technicality of failure to comply with a 30-day window for request for admission. And as the Meyer court went on to say, the discretion afforded the trial court under Rule 36.02 to permit the withdrawal or amendment of matters deemed admitted provides a modicum of flexibility to avoid any potential injustice that might occur from the strict and unyielding application of the 30 or 45-day deadline prescribed in Rule 36.01. Under those facts, it is this court's opinion that the order that I put down was appropriate. It denied the request to deem them admitted. And I think that the court, since I based it upon the language of the Tennessee Court of Appeals decisions that I think are most applicable, I don't believe that an interlocutory appeal to the Court of Appeals would result in any change in that. Therefore, I would have to make certain findings in a Rule 9 appeal. And I would have to make certain specific findings and statements that the legal criteria for making the order appealable is provided under subdivision A of this rule, which is basically the need to prevent irreparable injury, giving consideration to severity of potential injury, the probability of the occurrence, and the probability that review upon entry of final judgment will be ineffective, the need to prevent needless, expensive, and protracted litigation. I understand that the respondent's argument is that, hey, if I grant these requests for admission, then that pretty much is going to terminate this whole thing, because they're basically saying that it would render the petitioner's situation untenable. I'm of the opinion that my opinion was correct, my ruling was correct. I'm of the opinion that a court of appeals would affirm that, and therefore I do not find that there is a basis under Rule 9 for an appeal, an interlocutory appeal. This case has been pending for years. It needs to be resolved, and granting an interlocutory appeal would add probably another year of limbo while this case went up on appeal, and both sides were given the opportunity to present the transcript, the argument, the briefs, argument, set it for an oral argument. In 6 months to a year at least would be added to this case. So therefore, I find that the motion for an interlocutory appeal should be denied in the interest of justice. I deny the motion to alter or amend the prior order of this court. I'm going to put an order down that both sides will submit to the other within 15 days a statement of deficiency of discovery, meaning both sides will submit what articles of discovery are no longer or have not been supplied that were requested, or what the deficiencies are. And after the receipt of that, both parties will have 30 days to comply, to bring their discovery current, or file an objection to the discovery, which will have to be dealt with, obviously. In addition to that, I have reserved the question in my prior ruling about the failure to, if that either party wants to depose one of the parties, then they will have the right. That deposition will be set by agreement. It will not be noticed. And if the parties cannot agree, then you may contact this court, and I will set a date and time for the deposition of the party. All other matters are pending. I fully understand that there's Rule 10 extraordinary appeal that's available to the respondent in this case, and certainly they have every right to pursue that if they choose to. But it's my opinion that a grant of an interlocutory appeal would just be more damaging to the disposition of this case than denying it. So I have done that. And as far as your motion to compel, I'm not granting any sanctions to either side about that. I'm putting this order down to try to finalize the discovery. Once you have done that, I expect it will take several days to try this case. Is that correct?
Yes, Your Honor.
Most likely, Your Honor.
Your Honor, may I ask the court, instead of saying 15 days, because the computation of time, less than 30 days can get confusing when you don't factor in weekends, everything else. Can we just set a date certain so that there's no questions or loopholes for these parties to wiggle around with?
So what are you proposing?
15 days from today, Your Honor, would be what, 22nd of July? Is that correct? So maybe we just set
Today's
the
the
actual.
7th, 15th would be 22 days, 22.
So Your Honor, maybe we just set the date instead of.
All right, all discovery, the notice of deficiency of discovery will be filed by both parties by no later than July the 31st. Thereafter, both parties will have 30 days to supplement their discovery to correct any deficiencies. Either side has the right to apply to the court for a hearing on the discovery issues, but I want this to try to be resolved. Now, once you've done that, you're looking at the 1st of September before, and I'm back here in November. Do you have anything? You got your calendar. How long realistically, assuming that the Court of Appeals does not grant an interlocutory appeal under Rule 10, how long do we expect this to take to try this case?
I think 3 days, Your Honor.
How long?
3 days.
3 days.
Yes.
We could probably do it in 2, Your Honor, but just out of abundance of caution, so we're not splitting trial over months if we can help it.
Well, we've got more than one court with us, so even if you're not here. What about December the 28th, 29th, and 30th?
I'm available.
I mean, that's so far out. I don't have anything on my calendar, Your Honor.
Your Honor, respectfully, that's during the holidays.
Well,
And my son and grandson has a habit to come up here for Christmas on the 24th, and they stay till January 1st.
Where are they coming from?
Atlanta.
Well, I'm not going to.
And that's one of the 3 times that we get to see my son and grandson in the year.
And I want you to have that opportunity. So we will not set it on that night.
No objection, Your Honor.
Doesn't matter whether you objected. I'm not going to knock Mr. DeVault out of seeing his grandchildren.
Thank you, Your Honor.
Looks like it will be March 3rd, 4th, and 5th. Again, this is all based on, obviously, if they have every right to seek a Rule 10 appeal, and I understand that. But if there is no change in the status, then I'm assigning those 3 days as your trial date. Any problem with those dates?
No, Your Honor.
All right. I need an order drawn. Obviously, it needs to be drawn quickly so that if they're going to pursue a Rule 10 appeal, they need that order in the record.
Your Honor, respectfully, who is to draw that order?
I can draft.
Ms. Emmett will allow the petitioners to draw the order.
Thank you, Your Honor.
Let's try to get it done as soon as possible.
Yes, Your Honor.
Thank you, Your Honor.
All right. Ms. Roberts, you have the last case on the docket.
Thanks for hearing, Your Honor.
All right. Let me go backwards then and see. We had skipped over, I think, the in re Siobhan Martin.
Good morning, Your Honor.
Good morning.
We apologize for our tardiness. We were in the old courtroom this morning.
You mean you didn't find your way here?
We found our way eventually here. We're here this morning. I had filed a petition to appoint my client, Miss Holly Ezell, to be conservator over her sister, Miss Siobhan Martin. And Miss Green was appointed as the guardian ad litem in the case, and she's filed her report. And I won't speak for her, but if she wants to kind of highlight her report.
Your Honor, there's no opposition. The client is clearly in need of a conservator, and I spoke with her, and she was able to communicate in a fairly rudimentary way, but she was in agreement to have her daughter serve.
All right. Do you want to put your client under oath so that we can go ahead and let her establish that she's willing to serve and understands her obligations? So
Yes, Your Honor.
if you'll raise your right hand, ma'am.
Can you state your name for the record?
Holly Ezell.
Okay. And how are you related to Miss Martin?
I'm her sister.
Okay. what brought you to file this petition to become your sister's conservator?
She has been diagnosed with Alzheimer's. She will soon be 60 years old, so really young. She also presents with primary progressive aphasia, which is hard for me to say. So her verbal communication is almost gone. She had a hospital episode of 5 days where she no longer was mobile, no longer verbal, and it became very apparent that I needed to step in to help with her care and her insurance issues and other things. She was able to indicate to me that she wanted me to do that. So just trying to make sure that she gets the best care going forward.
And does she have any assets that you're aware of? Any funds in a bank account?
No, actually, I think her bank account is negative right now. Need to take care of that. But she has been receiving disability, but that is now being redirected to her current long-term acute care, or excuse me, a long-term care facility.
Okay, so that just goes to pay for her stay at the facility. Does she have any other type of income?
No.
All right. Well, clearly the record and the report of the guardian ad litem support this petition, so I'm happy to grant it. I'm glad you were there to take care of your sister. So.
And I do have an order, Your Honor.
All right. All right, I'll sign your order. Thank you.
Thank you, Your Honor. Thank you.
Let's go back to Amber Adcock Braswell versus Timothy Mark Adcock. We find anything out about? Do we have everybody here?
Yes, yeah, everybody's here, Your Honor. Yeah, Ms. Tracy.
All right, according to the docket, this is a motion to transfer and a motion to dismiss.
That is correct, Judge. My position will be, after you hear my motion to dismiss, it will take care of one way or the other the motion to transfer. So if I could be heard on that first, and we'll go from there.
All right.
Your Honor, if it please the court, I represent Timothy Adcock. I initially filed this motion to dismiss. It was initially set on November of last year. We were in front of Judge Turnbow at the time. And my client specifically had requested, Your Honor, hear this because Your Honor is the judge that heard this case for trial and subsequent hearings. So with Your Honor having the history before Your Honor would entertain transferring the case, my client wanted Your Honor to hear our argument to dismiss the matter. So I've outlined some of the procedural history in my motion. I'm sure Your Honor's read that. I won't regurgitate all that, but just to give a brief history, this is a step-parent visitation case. Your Honor did award step-parent visitation. At the time, I think you initially ordered it in 2021. It came back in 2022 for some sort of clarification, and it was confirmed then. But Your Honor did correctly and appropriately state Tennessee Code annotated 36-6303, and that references step-parent visitation by saying in extraordinary cases is that granted. And I think Your Honor went through the statutory requirements and found this to be an extraordinary case and did grant that. But also, our point is an extraordinary case of step-parent visitation is highly and significantly limited to step-parent visitation. The petitioner here, Ms. Braswell, is not a biological parent. She has no constitutional fundamental rights to this child. All she has is what this court has awarded her in terms of step-parent visitation. I believe the petition that she has filed, Your Honor, I think the major argument I have is simply that it's just not ripe to be heard. I think they filed it with some anticipation that my client had some conversations about relocating to the state of Michigan. And this was, again, conversations a year ago. My client is here today. He still resides in Tennessee. He has property in Michigan that he may eventually move, but he's not got any concrete plans to do so. My understanding is Ms. Braswell has been exercising her step-parent visitation as ordered. So again, I think the petition they filed is not right to be heard. My argument would be that if he were to relocate and she was not able to exercise her visits, we might have some contempt action or some a reason to potentially modify the case, but we don't have that. My client is here. She is exercising the visits. And I would even argue specifically the order that came out in 2023 that kind of reconfirmed her step-parent visitation made the following statement that said, if Mr. Adcock moves beyond the statutory designation of the parental relocation statute, at the time, Ms. Adcock's visitation would be 9 a.m. Saturday to 6 p.m. on Sunday. So my position was, at the time, Mr. Adcock had relocated to Texas. He's now back in Tennessee. But Your Honor's already contemplated if he were to move outside the parental relocation statute. So I don't know a new petition addressing him moving to another state would even apply. She's already been granted visitation in that context. She did in her petition try to, I think, inappropriately rely on parental rights statutes in terms of objections to parental relocation, custody, constitutional rights, which she simply does not have. Again, she's not a biological parent. She's not entitled to invoke the parental relocation statute. She's not entitled to ask for a guardian ad litem. Frankly, this is not a custody modification. She's not entitled to invoke a material change modification petition. I believe from our perspective on reading the law, all she has is extraordinarily limited step-parent visitation, which she is actually exercising fully at the moment. At some point in the future, if something happens and she's no longer able to exercise that, I do think she could come before this court or whatever court is hearing the case at that time to address her concerns at that point. But that's just simply not where she's at when this was filed. It's not where she's at today. So our position, in addition to all the arguments we outlined in our motion, would be to simply ask for it to be dismissed at this point because she's failed to state a claim upon relief that can be granted. She doesn't have the rights she's trying to invoke, and it's premature and not ripe at this time. So that would be my position on that. And I can take up my position on the motion to transfer. I don't think I'm going to argue that. If Your Honor denies our dismissal, then I don't think there'll be an argument to transfer it, but we believe it should be dismissed and there's no need for the transfer.
Good morning, Your Honor.
Good morning.
So I'm covering for Ms. Bailiff. I know she filed response papers. Initially my position would be that the motion to transfer was filed first, and that should be the first thing that's addressed, but be that as it may. With regards to the motion to dismiss, in addition to the papers filed by Ms. Bailiff, my position would be that this is in essence a third bite of the apple with regards to the father attempting to have this dismissed. This court found back on April 30th of 2021, it made specific findings that she was entitled to have this relationship with her stepdaughter, who my client is the only mother she's ever known, and that there was very specific reasons laid out. So my position would be that if the father wanted to challenge that, the appellate court would have been the appropriate place to challenge that, and that would have been within 30 days of that 2021 order being issued, or even the 2022 order, but neither time has it been appealed. So the issue has been that actually his relocation back to Tennessee has resulted in a lessening of her contact. When she was able to see the child in Texas, she was able to have a full week. So she actually had more contact with, for all intents and purposes, a child she considers her daughter while she was in Texas. I feel that she has made a valid argument for why she should be here, why the case should go forward. I can't speak to the entirety of the history. This court knows very well the history between these two parties. We would ask that it be transferred to Robertson County. Neither party lives here. And I would ask that the motion to dismiss be denied at this point in time.
May I just quickly clarify? Just for clarification, my client's not asking for her step-parent visitation. That's been ordered. He understands he has to follow that. His motion to dismiss isn't trying to affect her step-parent visitation granted by this court. He's asking for her current petition where she's asking for that to be modified, increased, or something to be dismissed is not right. He understands he's under your court's orders. Even if he were to relocate, he still has to facilitate the step parent visitation Your Honor's ordered. I just want to be clear. He's not asking for her step parent visitation to stop in any capacity. He's just asking for her current petition to be dismissed for lack of legal merit and ripeness and the other issues I mentioned.
And Judge, if I could just, maybe I wasn't so eloquent in how I stated that. My position is that the court gave her that right when it entered that initial order giving her limited time with this child, and that there has been a change in circumstances since that time period, which I think is really something for the trial court to hear through an actual hearing.
Well, on a Rule 12 motion to dismiss, the court is required to view the allegations of the petition that has been filed in its strongest light possible, and to determine whether, if taken as true, the allegations would constitute a grounds for relief with the court. In this case, Mr. Evans has pointed out correctly that the court entered an order back in 2023 that reaffirmed the right to the petitioner to have contact as a step parent with the child in this case. And I won't go back into the facts of the case, but in that particular case, it was probably the only time in my judicial career I've ever granted specific step parent visitation. But the court did find that that case was one that step parent visitation should be granted. The hearing in 2022, which is reflected in the order from January of 2023, was because there was some argument about the respondent, Mr. Adcock, having moved out of the state, if I recall correctly. And that's the reason that I put the order down, that's provided that if that her visitation with the child would occur every second Saturday of every month. If he remains in Tennessee, if Mr. Adcock remained in Tennessee, then her visitation would start at 9 a.m. on Saturday and end at 5 p.m. If he moved beyond the statutory designation under the parental relocation statute, then she would have 9 a.m. Saturday and end on 6 p.m. Sunday. And then I basically dealt with the fee requests and so forth. So there was a provision made whether he lived in this area or whether he moved beyond that area. In this petition, Ms. Adcock, she's now Ms. Braswell. Ms. Braswell is seeking to modify the court's order because she alleges that there's been a material change of circumstances, and she alleges that since the entry of the original order, he had moved from Texas to Tennessee, and that she has continued to exercise minimal time she has allotted with a minor child, but the minor child seeks to spend more meaningful time with her. So she also alleges that he has notified her that he again intends to move across country, and that those are the basis for that. In view of that, the court is of the opinion that there is a material change of circumstances alleged that would, and again, she's not entitled to the same rights as a biological parent. There's no question about that. My reference to the parental relocation statute had nothing to do with her right under the parental relocation statute, but rather was giving a benchmark to say that if he moved out of more than 50 miles away, then this is what she would have. If he stayed in this area, then she would have what was originally ordered. Step parent visitation cannot be held to be the same as biological parent visitation. It is limited, as Mr. Evans has said, but it also could be, it is an order of the court that is subject to a modification if there is a material change of circumstances, and that is what is alleged. And Mr. Evans says he's not moving, but that's a fact that is alleged. It's alleged that he's planning to move. He alleges it's not. And he also argues that even if he does move, there's a provision in the prior order that would provide. At this point in time, Mr. Evans, I'm not inclined to dismiss it based on my reading of the petition in the strongest light possible. But it doesn't mean that after some discovery that it might not be possible to renew your motion to dismiss before an actual evidentiary hearing. It would require this court to make some findings about that. She has moved to transfer this to Robertson County. Do you have any position about that?
Personal preference in judicial economy, we wanted Your Honor to hear this motion to dismiss, at least given your history. My client would probably prefer, just because Your Honor's heard the case, but I can't argue the fact that neither party was right in Cheatham County at the point, which is the point they're making. So I have to be straightforward with the court on that. As a preference, we would prefer Your Honor to hear it, but we don't dispute the fact that neither of these parties now reside in Cheatham County. So we'll just leave it to Your Honor's discretion on that.
Well, neither party is a resident of Cheatham County. They both reside in Robertson County right now. It seems to me that's more logical venue for this action, since that's where all of the evidence would be. So I will grant the motion to transfer to Robertson County. If you will draw the order, of have Ms. Bailiff draw the order, please.
Thank you, Your Honor.
All right. The rest of it, sir.
Nice to meet you.
Yes, go ahead. Philip Crandall Brown versus Shelby Lynn Squires. All right, and this is Ms. Squires, you were representing yourself in this matter, is that correct? And you have filed, I think it's the initiating pleading that was filed was an ex parte petition for relocation, in which you allege that due to exigent circumstances, you are requesting that the court allow you and your minor children to relocate to Butler, Indiana. So that is the matter that's before the court. You appeared last before this court in 2023, if I understand correctly. And in response to your motion, the father has filed a motion to enroll the children in Cheatham County schools. It's been quite a while since I've had any contact with this. I'm going to step off, take a short recess to look through this file. I want to review the last orders that were entered before we come back. It will probably be about 10 or 15 minutes.
All rise.
Just give an update.
Yep, we're in here or there tomorrow. I think we're next door. I think the new next door.
Yeah, the new reception.
Okay.
It's been
We haven't done it.
debate. Depends on the judge.
I was
Still.
okay.
Yeah,
I didn't know.
it's
I didn't
short.
realize that.
I know.
We can all be over here. You can sit over there.
No.
And I don't blame he was out here.
Why would he? Here you go.
That was the
So,
dad.
yeah, just whenever. Do not texting on this app. It does not do any other thing.
If you got your income expense, I would do
I
something.
do, but I have. Thank you.
They might go to Walmart.
Oh, well, they can kill them all there. Ours is Lowe's. We walk around Lowe's when we need to kill time in the AC. Oh, yeah.
And I'll call it.
Shopping trip.
Outside.
Outside the buildings? Okay.
quickly.
Yeah. We're good.
When did y'all get in this room? I was gonna say, I feel like I was here maybe 2-3 weeks ago, and it's nice. Nice. Working out the kinks. It'll take a little bit to get used to. It was. Much nicer back.
As big as this. Doing mass in there. It just got too crowded. They were allowed to go to
different.
The African church. Really almost 2 years. They had to get the walls. And then now,
Some of those you'll get used to. Functionality is a little different, but yeah. Decor you can get used to. Yes, ma'am.
Yes, there's.
Sonny, where did this come from?
P.O. Box.
Okay.
To move around.
Look how we had it changed.
Get to the door quick. Are the acoustics much better in here? I feel like he always had a hard time hearing in the courtroom. Not for me. Nobody's ever accused me of being quiet, but.
States in there.
Yeah. Yeah.
Didn't go. I just grabbed water. I was like, man, I probably won't. Yeah.
Or is there going to be an entrance coming into this side at some point? Still go the other way. Yeah.
Right there.
Make sure you iron the back of the shirt now. Stretch it.
And get in the shower when you get ready to get a little steam on it and put it on.
Yeah, so right now, pretty much. Kentucky.
Have you all ventured out to see Toy Story yet?
Toy Story.
The news. You did, was it good? We were gonna do the drive-in Friday to see it. But then Watertown.
Oh.
And then Friday earlier, I mean, it was thunderstorms. I was like, I'm not chasing a 3-year-old around a wet drive-in. That like we were pushing it to do the drive-in. We're pushing it to do that, but I was like, no, not in a mud pit.
Well, every
school in North Carolina. As client's house had to stop by. Took the girl to see waterfall. Jim told me they were upset they didn't get to bear. Also took them on the drive. Famous Tale of the Dragon.
Oh, yeah.
Drove that. Motorcycles and all sports cars. There's a pretty scenic valleys and waves. Stop at the previous one. Next time we take the kayak, so we kayak up to the
How old were they when they started doing kayaks?
They're still really inviting me to get to it too.
I've not ventured into the kayak yet. Thank you.
Assumption.
How much?
Finished up. Assumptions, issues. She got on with it.
Did they have anything on the?
Nope.
That's one good thing about him. He does read pleadings.
Yeah.
I hate when you've spent time to get things drafted and just tell me why did I spend that time and waste your money?
Childcare in school. Kids aren't in like their classes, so that would be long. They have other ones. There's other ones who would come off as well. Out of the same ones.
What y'all do for the fourth?
Two groups fires. Front rooms, film pit. Music history shop. They do lessons. Private lessons and all that. So she's when they probably great too. So they have the there's stuff there people could sit on tables and all that. She's right on highways. We just shut it down. And so we got out there, food, trees, and everybody sparklers with the kids. We were gonna go there. I did chili cooking later. It's a fundraiser for them because they get free buses. That was a pretty chili competition. Winning category every year. And we did win that last year, or 2 years ago, actually won 3 or 4 categories. But only took the win. Was not usual.
Chili's not my strong suit. I love it. It's just not my strong suit. It makes it entry worthy.
That one was an Irish called it drunken leopard. Had Guinness, Irish style, along with Irish meat. Pork, beef, and bacon. No beans.
I asked him, well, you're in Nashville. Did you go see those fireworks? Well, you couldn't pay me enough to get down there. My brother's a school teacher, but he works for Pyro in the summers. So he's done the Nashville show a couple times. He's like, you coming down to see me? Sure, I'm not.
Not unless I'm on that side for your launch.
I mean, I'm just not getting in that crowd.
Oh, yeah.
He's flying back today. but the last couple of years he's done 4th of July show in Cuba. It's like under the base and what a grown man child doesn't want to get paid to blow things up in Guantanamo Bay.
Sign me up.
He's always looking for more people to go. They go out. They'll do shows off the coast of Florida and Alabama and different places too. But they're out on these big barges out in the ocean. I mean, and they're just, I mean, there's no safety belts, no nothing. I'm like, but he'll just look over and hold his phone. I mean, you can just see massive sharks just circling. No, good.
Cherry Music Festival this month.
Indiana.
Stage. Start on the stage on the 22nd. Finish stage on the 23rd. And bring out sound equipment. And 24th. Afternoon and evening. First day. Next year, my buddy Kevin, we're actually taking over. We'll be incorporating its own individual 501c3.
Is it local performers or?
Region. But that money looks good. Unfortunately, this deadline is like a paper for Cheatham. Cheatham's another sponsor for the past 3 years. It's messed up this year.
Looks like it's
it's down to session. Every now and then we get but it's an officer, not sitting there, and the officer presents the case, clarifying questions.
You see the shelves at the bottom?
I was wondering what that little shelf, that little drawer was for.
Is it supposed to be like a key one?
It locks.
But that's the only way to open it. Stick a key in it and open it.
One time deal, you get one shot to put something in. They can ask us questions.
Well, but why would you?
There's no point of it existing.
I mean, what am I supposed to be bought a thousand or leave or something?
Somebody might open this or that, they can step on it for 10 days.
Yeah.
That's what I'm looking at. It's just about the door. No, I think there's like a little.
Now there's
like a little space at the top.
Is that a drawer or is it an extra shelf that you can like put papers on?
Never go there, you got a shelf.
yeah, it's just an empty shelf, and then these are open. They're not locked. You just have to.
It's a big hole in the bottom.
There is a big hole in the bottom.
Just for the wire.
Ah.
Like you got a wire, it's just
So it's just, it's to get access to the wiring.
I go downstairs at this point.
Yeah, but on the see.
Yeah, like when people used to have the projectors, that will make sense.
Well, but I guess you could, when you have a big file, I could put, because this is just a little bitty lectern. You can't open up a file on it. So that'll be a good thing where you can put your exhibits and stuff.
Or it's good though.
HDMI for the laptop.
Yeah, it's a laptop there and you can flip through things too. Because it's got the
Oh, it's
cord
got them on
coming out.
both, so you can balance it out. It'll smack that table. And then you can't see the witness chair at all from over here.
It's good. Yeah, yeah. I see that now.
Yeah.
Okay. Is all this bolted down?
Well, you know, when they did did Dickson's, you know, the new Justice Center in Charlotte, it was the same thing. I mean, it's a beautiful courtroom, you know, all the bells and whistles. But practicality was, is they built this huge lectern. They put all of the wires for everything for the lectern right in the middle of the floor. So when you stand at the lectern, you can't see it blocks you can't see the jury at one point. You can't see the witness. I mean, it's just not functional. If they'd have just scooted the lectern back, then you wouldn't block the other side from seeing the witness, you know, and they could see it and do it. So it's just little things that, you know, they should have asked people who actually used the courthouse, you know, used it as a functional courtroom. Because again, if you have a jury trial in here, the state's going to sit over here. As somebody who used to practice criminal law, I'm kind of happy about it. I don't do it anymore. But the jury can't see the defendant. So, you know, when the jury's over here looking how the defendant reacts to
whether or not we're going to be able to co-parent with medical problems, or if those medical issues of the children are going to be addressed while in Mr. Brown's care.
All right. You have a seat then, Ms. Knight. You may make your opening statement. So.
You've heard this request for mother to relocate out of state at least on 2 other occasions. At the beginning of the divorce in 2020, mother wanted to move to Oklahoma. This court denied that. Then in 2023, you denied mother's request to move 7 or 8 hours away with the children to Indiana at that time. Father wasn't even having that much parenting time with the children then. Over the last 3 years, he has a set schedule, a routine. He's heavily involved in their lives. And now, because mother's refusal to maintain employment, she's faced several evictions. She now wants to move back to Indiana and take the children again 7 or 8 hours away from father, preventing him from being a constant figure in their life. I have no doubt if the court allows mother to move, father would still receive parenting time, but simply based on the distance between the two, it wouldn't be an every week, every other week situation that these children have grown accustomed to. This is once again mother trying to alienate father from these children.
Ms. Squires, you may come. Are you your sole witness, or do you have other witnesses?
Your Honor, at the last hearing, I did ask that both Allison and Claire Brown be present. Are they available? And I wasn't sure if Your Honor would like to speak to them or not, so I had asked.
How old are these children?
Allison Brown is 11 years old, and Claire Brown is 6 years old.
Certainly, a 6-year-old is not going to be a witness that this court is going to allow to be put on the witness stand. The 11-year-old is discretionary with the court, but I'm going to hear your proof first before I make any determination. The request that you made about having the children present was in front of a different judge, and I don't know that I will want to hear from the children as well. So,
just so the court is aware, I objected to the children being present at an ex parte hearing. If the court wants to have a final hearing and feels it appropriate to talk to the children, they can be made available. The children are local in town today, as somebody's caring for them and can bring them in if it's necessary.
right. Well, this is a hearing on your ex parte petition for relocation on an emergency basis. So if you want to come around and testify, I'll be glad to hear it. You'll come around here. You'll face our clerk, raise your right hand and be placed under oath.
I do.
Have a seat, please. Ms. Squires, I know you've been through many court proceedings. You understand this is your opportunity to present to me your testimony about why you believe that it's in the best interest of your children and why you are requesting this emergency ex parte. It's no longer ex parte, but your emergency request to relocate.
Yes, Your Honor.
Make sure that you're close to that microphone so that, hold on just a second. I'm going to see if I can make this a little easier for you. Ms. Knight, can you see on the screen?
I can, but I can also see the witness in person.
Okay, can see the
I can.
Right. All right, Ms. Squires.
All right. So as I've provided several documents in the petition, words exchanged between past landlords to show that there were proceedings taken towards an eviction. I had signed a lease back in 24 and went through that for a year. And unfortunately, when I renewed, I was not able to do that without a roommate. And That unfortunately did not pan out. The landlord proceeded with eviction, and I was able to settle with him out of court, so long as I vacated the premises. Then moved in with a neighbor for the remainder of the school year. I was hoping that was going to be a longer situation. We had agreed on a payment plan of $450 a month. We didn't have any kind of a written agreement. It was a verbal agreement. And it is my belief that she wanted to be getting more than $450 a month. And that's why the lease was terminated, or the agreement was terminated, the month to month verbal agreement that we had. She did keep my last month's rent. And I was unemployed at the time. So I had looked into possibly moving back up to Indiana because my grandmother does have a country home with multiple bedrooms to where the girls would be able to each have their own room. We would be closer to family where they could play with their cousins. Mr. Brown's grandfather is also up there. And then also with my grandmother, it's not just a memory issue with her. She's also had multiple eye surgeries, so she needs help preparing meals, traveling, different things. So we've prepared a rental agreement that started from June 3rd of 2026 until May 30th of 2027, and I have copies. If
you would tender that to our bailiff and allow him to show that to Miss Knight.
And so this shows that
Is that the same copy that you have?
the same copy for you as
If you want to just hand it to me.
oh, okay, I'm sorry. Um, I apologize. And on the first page, if you go down to rent, it says tenant shall provide the following assistance to the landlord in lieu of a dollar
This is your
amount.
grandmother?
Yes, this is to show proof that I was able to establish residency up there and have a home that would be suitable for the girls.
Okay.
So being able to help her out with the care of that property in lieu of rent is going to be a huge advantage for us. And then with the caretaking, it is going to take a little bit of time to get that established. She'll have to have a doctor's appointment as we go through all of that. But it has so we would be applying for me to be her live-in caretaker. It would go through her insurance. They would compensate me based on the level of care that they deem that she would need. I can't speak as to what level they would do. I'm not a doctor, but that would at least help secure employment and then training for future employment. So these are the plans that I've been able to prepare as something sustainable, because we've been going on now several years to where I've been kind of going back and forth on housing. And we need something more stable in order. I mean, we can't keep losing places like this. It's not that great for the girls or I. So this would be an opportunity for us to have that stability, take some of the stress and the wonder off of what's going to happen when one lease ends. And then I had every intention of coming in here hope, like when I wrote my petition, I'm writing things such as the children go with Mr. Brown and Mr. Brown brushes their teeth every night, or Mr. Brown is to bathe the children every other night, or Mr. Brown is to give the children prescribed medication. I feel like these are very basic things that we should be able to come to an agreement with. I don't understand why we're still having kickback with that. I've had times to where the girls come home and the hair is so tangled that I've almost had to cut it out. There were times several years ago to where they were coming home with UTIs because they were not being bathed for the entire week that they were with Mr. Brown, or for the whole weekend when they were with Mr. Brown. We'd had multiple different conversations, and it just felt very much like his house, his rules. I don't get to know anything that happens over there. I don't have any say in it. When it came to Clara being smaller, I remember our child is in like the first percentile of growth. She's been that way about since she was born. I had a condition called placenta previa, which did affect her growth weight. And it was always kind of wondered whether or not she'd have to have a growth hormone. Her pediatrician recommended that we put her on an appetite stimulant for a while to see how she would react to that. She was on the medication for a while, and as we started approaching longer, all of a sudden I started hearing from Mr. Brown and my daughters that Clara no longer needed her medication. And when I asked why, I was told that was because her appetite is fine over at Mr. Brown's house. And I'm going to go ahead and I have a picture of the bottle of the prescription. There's 2 copies here. So it's an appetite stimulant. It comes in a liquid form. She gets 5 milligrams every evening. It's supposed to be taken in the evening because it can make you tired. It is not something that you take and it instantly stimulates your appetite. It's something that you have to be on consistently in order for it to have effect. So when she's been on the medication with me for a whole week, of course her appetite's working just fine over at Mr. Brown's. But by the time she's over there for a week and she comes back, I'm noticing a significant difference in what she's consuming at the beginning of the week versus the end of the week. And then on Friday, June 12th, was a week that the girls were coming to me, and I've been sending the medication to Mr. Brown, even though I'm fully aware he is not providing it to Clara. I had texted Mr. Brown that Friday and asked him not to forget Clara's medication. He had handed me some bags at the exchange. I didn't realize until we were on our way back to Indiana that he had not provided the medication. I tried to reach back out to him when I found out I would not be able to fill the prescription in Indiana. I did not receive any kind of a response from that, which is fairly typical when it comes to a lot of medical questions, or like if I ask him if he wants to attend an IEP meeting, it's almost surprising when I do get responses on.
Let me interrupt you and ask you this question. Where are you presently living?
I am presently living at my grandmother's house in Butler. Yes, sir.
And how long have you lived there?
Since June 3rd.
All right. So since you signed this agreement.
Yes,
and you want this agreement to be made an exhibit to this hearing, is that correct?
Yes, Your Honor.
Be marked as Exhibit 1.
No objection.
And from June 3rd, when you moved to your grandmother's house, over the 30 days that you've been there, where are the children?
We have been going back and forth. Every Friday I've been driving down and picking them up and then driving back. So I'm driving
And that's pursuant to the prior order which gave you alternating weeks during the summer?
Yes, Your Honor.
Okay, all right. That clarifies it for me. Thank you. Go ahead and mark these. I'm marking this photograph of the appetite enhancer, or whatever you want to call it.
No objection.
Okay.
As the next exhibit, along with the text message.
Mhm.
Mark
As
those two
a
exhibits.
collective 2 or 2 and 3?
Collective 2. All right. Sorry, Ms. Squires. Go ahead.
Oh,
Now,
no,
you signed this agreement as Shelby Brown. Are you going by Shelby Brown or Shelby Squires?
It depends on if you're asking the state or Social Security, Your Honor. State of Tennessee has
I'm
me as
talking about here in this court. How do you want to be addressed?
Shelby Brown is just fine.
Go ahead. I'm sorry.
You're fine, Your Honor. Thank you. I apologize. I do also have text that I had received on Thursday, June 4th. This was the day after we had just had court. Or this was the day just before we had had court. I was working to, when I had initially filed the petition, I had a misunderstanding. I had believed that the order was signed, especially when I seen Miss Knight give her notice of appearance. I just assumed that the order had been approved, and that's what we were waiting for on this hearing. I didn't understand that it had been denied. So when I was made aware of that and I came back into town for the hearing, I had reached out to Mr. Brown and told him that I was back in town, tried to meet with him to get the girls, and down at 1:39 p.m. He had agreed to give her lunch, but then he turned around and said that she did not eat. So he claims that she's eating just fine during his time, but that is clearly not always the case. And then, now with, in my petition, I did make the court aware that their child services is investigating currently. Our history with child services began back in either 2020. I know it was Maxie that ended up being the first person to call in child services on us. I believe Mr. Brown was investigated at that time for child endangerment, and I was investigated for failure to protect because I had not contacted authorities.
When was this?
This was in, I believe, 2020 when we had first came in and put another order of protection that was in front of Maxie.
And you understand that that's now evidence that already been heard by the court and already been considered in making the prior rulings. So what we're talking about now is what has happened since the last order went down in this case.
Yes, sir.
That would justify you being granted the extraordinary remedy of moving to the state of Indiana and taking the children with you.
Okay. Well, it would get into with child services being involved.
In 2020,
they're currently involved as well. I was investigated for failure to protect back then. That was denied. Then again, in here recent, I'll just skip to here recently. I apologize. In December of this year, my therapist through Centerstone.
December of 2025.
25, yes, sir. My therapist decided to go ahead and make a call into child services based on some things that she had heard during one of our therapy sessions. I have been discussing The lack of hygiene of the girls when they come back into my care, them coming in clothes 2 years too sizes small, the knots in the hair, the not bathing, the children not brushing their teeth for the entire time that they're over there. And I had just gotten this woman as my therapist. She was newer, and I think maybe, I don't know if maybe that's why she called. But I mean, everybody in the state of Tennessee is a mandated reporter. So when you hear something about that, I do feel like you are supposed to call, and I was glad that she did. But it's been since December, and Child Services still has not been updating me on many of these things. They ended up actually losing our case for several months and failed to complete a transfer over to Cheatham County, so that way this county could continue their investigation into the accusations against Mr. Brown. And I still have not received an update from them. They have been made aware of the Clara Brown not receiving her medication. And it is my understanding that they have performed a home inspection on Mr. Brown. And I did put a stipulation into the petition, or the ex parte order, that should Child Services deem it necessary to charge Mr. Brown with anything, that the children should, instead of being with him, come to Indiana with me immediately. And I'm wondering, like, we're going to have to switch over the insurance. We're going to have to switch over the school up to Indiana. But if I can't get basic communication about if we're going to the eye doctor or getting medication to my youngest child, I'm kind of at a loss on what the best option is going to be going forward for this.
Is there any other evidence you want to have the court consider regarding your request?
Yes, in the petition, there is a doctor's note from Mark Their Words Therapy. I apologize. I think I do. I'm sorry. I'm not sure. I'm going to have to. This is answers. I apologize. I do not. I'm not quite sure where the form is. With the petition, it was. There's two different forms of therapy that the children have been receiving. Clara Brown, the 6-year-old, she's been receiving speech therapy services from Mark Their Words Therapy. She received those for about 1.5 years. A year before she started school, and then about halfway through the school year, she was receiving those services in addition to speech therapy through the school. With Mark Their Words, their program, the way that it's set up is you go in for a set schedule for a set amount of time. For Clara, it was deemed that she should have 3 sessions a week, Monday, Wednesday, and Friday. I was able to get her to those appointments during my parenting time, but when Mr. Brown was getting the children every other Friday throughout the school year, he was refusing to make appointments for her speech therapy. I had offered to drive her I had offered, like, Zoom was an option. That could have been established. But I don't know if it was because he did not like that she was withheld from kindergarten, that he just decided that this was not something that she needed to have, or what the reasoning was. But I do believe that if my daughter had had participation from both of her parents, that she would have been better prepared to go into kindergarten. She has an extreme phonological disorder, which means her speech, the best way I can describe it is that it's like dyslexia with sounds. Instead of reading and things are flip-flopped, it's when she's speaking, her sounds come out different. Like, it took her until 6 years old to be able to say ketchup properly. So that causes not just issues with her education and being able to properly read and form her phonics right, but it also causes social barriers with her making friends, or feeling like she's not enough when she's the only kid in the room that's not being understood. So I don't believe it was just her education that suffered. I believe it was socially. That was something that she lives with. And I know she's sick, so as far as witnessing to anything, even if you could just hear her speak, just to hear her vocabulary, you might get an understanding on why I felt it was best to pursue the speech therapy the first year rather than putting her straight into kindergarten. I didn't want her to be so frustrated that first year that she just gave up on school. And then the other type of therapy that our children are receiving, Allison Brown, our 11-year-old, has an anxiety disorder, and Claire Brown is diagnosed with ADHD. They both see Molly Fields, who is a Centerstone-based therapist. She's been the school therapist out of the Montgomery County schools that we've been able to get into. They receive sessions about a couple times a month for various things. It took a while to get Mr. Brown to participate in that, but he has started making appointments this summer. And I have appreciated that greatly. And I will say, if the motion is granted for us to be able to go up to Indiana, Centerstone does also practice in Indiana. That is one of their other states, so those services would be able to switch over. And I believe that's what I have.
Ms. Knight, you may cross-examine.
And I'm sorry, pardon me for asking. You said you wanted to go about Miss Brown. Okay. Miss Brown, you mentioned you've once again come into some housing issues. Since we were in court last on October 2023, how many different residences have you had?
Since 23, my grandma's is now number 3.
Did you live with Carol Hinger?
Carol Henniger at 1532 apartment 4, which is where I later signed a 24-month lease for. She had moved out of the apartment and I took over the next year.
And when did you move out of that residence?
That was let's say March 11th of this year. And I moved in the same building, but Unit 6, and I stayed there until May 20th.
So since 23, you've been in the same apartment complex?
Until I moved to Indiana, yeah.
Okay. So there wasn't an instance in 2024 when you lost your housing and you had to ask father if the children could stay with him?
That was right before I had moved in with Carol Henniger.
And you didn't live with her in 2023?
I don't remember the exact date that I moved in with Carol Henniger. I lived in a domestic violence shelter for about a year and a half, and then I had an apartment for a year in Millertown. And then that was when I had contacted Mr. Brown because I was concerned that I wasn't going to be able to keep a roof over their house or over their heads. And then Carol had offered to allow us to move in with her, and she had been the director of the domestic violence shelter I'd stayed in, so I'd built a relationship and felt that I could trust that situation.
And is that an address that you gave to father, or did you withhold that address from the father?
At the time, I was in the state of Tennessee's address confidentiality program, Safe at Home, and I was in that program from 2020 to 2024. It is not a housing assistance program. It is strictly to hide the address of victims.
So you said you moved into Miss Henniger's apartment.
Mhm.
She left, and you stayed there until March of 2026.
Yes, and I had ended up, I had decided not to renew my participation in the Safe at Home program because I knew Mr. Brown not knowing where his children were was a point of contention, and I was hoping to just ease tensions. That's why I withdrew or didn't renew my presence in the program.
So in October of 2024, did you sign a new lease?
I do believe that's when I signed a lease after Carol moved out.
And did your father co-sign that with you?
Yes.
And did you re-sign that lease at any other point?
I did either, I'm trying to remember the dates that I had signed it. I had signed again without my father. I had a previous partner that was living with me, and he had signed on to the lease. I want to say that might have been October, November 25. If I had provided that info, if you could correct me on that date.
And then you moved out in March of this year from that apartment?
Yeah.
And you moved into, you said, your neighbor's apartment.
Yeah, I'd had a neighbor, and we thought we were going to be able to make that work.
How many bedrooms was that apartment?
2.
Where were you and the children sleeping?
We were in one room.
Did you think that was a good option for long term?
Well, it was better than a car.
And then you moved to Indiana in early June of this year.
Yes.
When is the last time that you had stable housing?
Since I've had stable housing, that year that I had signed the lease, that was about the last time I was not struggling to pay rent.
Okay. When was the last time you were employed?
Currently running a little bit of self-employment. I was able to bring in, let's see,
Can you explain what that employment is before you explain the income, please?
Sure. I still need to file for the business license, but I am doing just various goods and services. I've got a couple of art wares that I do, different sun catchers, and then I just offer labor. Somebody needs somebody on the farm to work, or you need a laborer, I'll jump in.
When did you begin doing this self-employment for goods and services?
I had attempted to last year, but I wasn't able to really get it off of the ground. I put more effort into it when I went back up to Indiana. I had more. It's a lot easier to sell goods when you know some people in the community. Just from my parents had known a couple people. My grandmother, just having different contacts throughout the church, just kind of made it a little bit easier to get my foot in the door.
When is the last time you had a traditional employment?
Traditional employment, I did delivery driving for about a year. That was after Firehouse Subs.
Okay. Well, tell me about your delivery driving. Who were you driving for?
I did a combination. I had multiple different apps, DoorDash, Uber Eats, and I would drive for whoever was running the better promotion.
How much were you earning then?
It varied. On a really good weekend night, I might be able to bring in 150
per night.
Yeah, and I mean it varies some on the take home. Like that may have been what the app says you paid out, but that doesn't take into calculation the gas expenses and everything. So, and after I ended up taking the cost of everything, I ended up being in the negative because I ended up having car problems, lost the car, so that job actually cost me.
How many hours per week were you doing that job? Approximately.
Gosh, probably 25, 30.
And how long did you do that job?
A little over a year. I want to say that car blew. I want to say that car blew right before 25. I want to say it was December of 24. Yeah, I think it was 24.
Did you earn any income in 2025?
I had money from donating plasma, but I was told that wasn't a taxable income.
How did you support yourself and the children in 2025?
I had different family members that were helping out. I hit different food drives, was doing that. We had cut back down on rent to the $450.
When did you work at Firehouse Subs? You mentioned that employment. Was that before or after the delivery driving?
Before.
How long did you work there?
I don't think it was quite a year.
How much did you earn there?
I want to say that was around, I don't remember the exact amount, but I want to say it was around 11 an hour.
Do you know approximately how long you would have been working, or how many hours per week you were working?
It varied, but that was around, I think I was only getting like 2 or 3 nights, maybe 20 hours a week.
I want to pass you something. Just one for the witness at this point. Ms. Brown, I want you to look at this document and tell me if you recognize this document.
Looks like supplemental response.
Okay. Flip through. Are these discovery responses that you provided to me previously?
Looks like it.
Okay. Would this have been during Mr. Brown's previous petition to modify the parenting plan in 2024?
I believe so.
Okay. If you flip to page 2, there's a question that states to please list all employment you've had since the October 5th, 2023 hearing.
Mm-hmm.
Do you see that question?
Yep.
Okay. And then flip to page 3. Do you see your answers there?
The Firehouse Subs, Uber Eats, and DoorDash.
Okay. So the question was, since October, the last hearing in October 2023, please state all of your employment. And you said Firehouse, Uber Eats, and DoorDash. That was all the employment you had over the last year, correct? At the time you answered these.
Yes.
Correct. Okay. And why did you leave Firehouse Subs?
I ended up falling for a scam.
What is the reason that you gave in your discovery responses as to why you left Firehouse Subs?
Let's see.
It's on the top of page 3.
Found better paying work.
You found better paying work. So you left one job for better paying work.
Yeah, the Uber Eats and DoorDash was better paying.
And you said, and when did you begin Uber Eats and DoorDash?
Looks like August of 24.
Okay. And did earlier did you testify that your car blew before 25? Was that your testimony earlier?
The car would have been December of 24.
Okay. So did you stop working Uber Eats in December and DoorDash in December of 24?
That's I believe so, because I mean, when the car blew, that's when I did it, and it wasn't this past December, so it wasn't December of 26. It would have been December, or not December of 25. It would have been December of 24 when that car blew, because I've only had this green car for a year. So
you've had this new car for a year.
Yeah.
And in that last year, have you obtained any other employment other than attempting to sell some goods you've made? Prior to moving to Indiana. Any employment in Tennessee?
I had actually applied through the IPS program through Centerstone. I believe I have that flyer over there, though I have only got one copy of it. The IPS program is a program ran through Centerstone specifically to help people with mental health disabilities get back into the workforce. They had somebody that was supposed to run the program. I was on the list for like 4 or 5 months before we finally got the ball rolling. And when they finally had started getting my employment lined up to help me with employment, that was when I lost my apartment and then ended up going up to Indiana.
So that program's to help people with mental health disabilities get back into the workforce?
Yes.
You're asking this court to allow you to move 7 or 8 hours away, several states away with your children and take them away from their father, correct?
Yes.
Based on your inability to secure stable housing and your inability to obtain employment. Is that correct?
In part, yes.
But you've not even made any efforts other than applying with the program. Have you put any applications in at any place of employment in the last year and a half?
Yes, I have applied to Lowe's. I've applied to Walmart. I I have several other places I've employed to. I would have to get that list for you, and we can go over that in Discovery if you'd like. So I have made several attempts to gain employment, and the mental health disability that I have is due to repeated mental stress and abuse that I incurred throughout the relationship with Mr. Brown, and then dealing with trying to co-parent with him after the fact. So yeah, I know it doesn't look great that I haven't worked that much, but I've still stuck with my therapy. I've still gotten sober, and I'm still at least trying to gain employment through means on my own, and then also applying with people that are willing to help me gain employment.
And do you think your mental health is going to miraculously be much better in Indiana that allows you to hold down stable employment?
Well, mental health is kind of a journey. It's not something that just fixes itself overnight. I've had 6 years of therapy, and though I'm not sure that I'll continue with the talk therapy at this point, I'm still going to continue with my medication. What I would like to say is that by this point, I have gained a better understanding of my condition, a better understanding of my triggers, and a better ability to use healthier coping skills, and to recognize different situations to where maybe I need to step away from in order to, maintain that sense of not being so panicky, not being so flighty. For example, I don't go into large crowds very much anymore because I know I'm going to get overstimulated. I'm going to get overwhelmed. And I'm 21 months sober. I haven't drank. So that was a major improvement as well, to stop the drinking and then get medication. So I know my mental health isn't, it took 6 years to get me to this point, and I've maintained the sobriety for so long, and I'm still taking the medication. I'm actually very proud of the progress that I've made so far, and I do believe that if put into the right type of environment where I can have the support of family and just be a little bit more comfortable with having a stable living environment, then I can provide, good work to be able to support me and my family, contribute to society. Like, I'm not completely to the point where I need to be filing for Social Security disability, and I would like to get to work now.
You said you're not to the point of filing for Social Security disability. So you are able to work, correct?
That's what I'm doing at the moment, yeah.
But over the last year, year and a half, you've not had stable income.
Not consistently, no. There was a major shift. I felt very held back by having to stay in Tennessee. I didn't feel like I had a lot of family or friends to support. Felt very kind of closed off. And then, even though I'm not proud of losing the apartments, since I started filing this paperwork to see if Indiana could be the potential future for my daughters and I, there has been a shift, especially with the caretaking. That's my grandmother. That's something that I would be honored to be able to do for her.
But my question was that you're not to the point of needing to file for Social Security disability. So your mental health is not to the point that it prevents you from working. Is that correct?
I would say that I haven't been steadily employed, so I feel like that kind of speaks that the mental health was clearly contributing to some bit on whether or not I was holding a job or not.
Do you have a degree?
I do, in graphic design.
Have you ever tried to work with and utilize your degree?
Yes, through several aspects. With graphic design in 2023, we were working with Photoshop, basic Adobe products. Now we're I mean, when I got into the market in that field, that's kind of when Vistaprint and, a lot of pre-laid out stuff was already available. So people were going to that option rather than paying somebody $75 for a design charge. The other part of my degree is in business, and I have been able to use that in several different fronts. I was able to use it when I applied to be a veteran service officer here for Cheatham County. And unfortunately, Montgomery County did not want me because I was not a veteran. I was also able to use the business degree when I have a job at Colby's Army, doing various filings for them and their grant.
When was the last time you worked at Colby's Army?
Well, it's been a few years.
Did you work there at all in 2024?
No.
In 2023?
I don't remember the date that the grant ended my employment.
So it's been a while.
Yeah.
Have you ever applied for unemployment?
No, I had not. My understanding was that I wouldn't qualify.
Can I pass you something? Would you take a look at this document and tell me if you recognize this, Ms. Brown?
What specifically are you wanting me to look at?
Just this document in general. Do you recognize this document?
Not from memory, but I'm reading the title here, so I'm assuming it was the answers to interrogatories.
And if you flip to the very last page, is there a certificate of service that says this was from July 12th of 2024?
Yes.
Okay. So is this your discovery responses?
Looks to be that way.
Somehow the page numbers are not on what I received back. But if you will look at...
Okay, actually, I see it here.
Interrogatory number 14.
Yeah, where it looks like I did apply for unemployment, but cease to pursue because apply for families first, but cease to pursue. Okay, so these were back in 24.
So in 2024, you did apply for unemployment, correct?
It does looks like I applied for it. I know I never received it.
Does your discovery responses indicate that you applied but ceased to pursue?
It looks that way.
Did you submit sworn discovery responses that also state that you've applied for families first but ceased to pursue?
Yeah, the families first was something that I had ended up deciding was not going to work for my family and I, because my understanding is that it's more like a loan to where they will. I kept hearing from caseworkers and everybody that they would give you a payment, but then they would turn around and take it out of your child support, and that just sounded like kicking the can down the road. I didn't understand why I would do that.
So in 2024, you applied for unemployment, so you weren't working at a point in 2024, correct?
Correct. So this is.
And you chose not to pursue opportunities that could help you support your family, correct?
Well, if this is right before I gained employment, then.
When did you gain employment?
Gained employment at Firehouse. Would have been August or September, so right after this.
Can you go back to the other set of documents that I gave you? And look at page 3. Where it talks about your Firehouse subs employment.
Okay, yeah. So this says. Oh, okay. So this was in April. So I was already working at Firehouse before this was filed.
So you worked at Firehouse subs. You said April 2024 through April 2026. Is that correct?
That's That looks like what I submitted.
I'm sorry, April 2024 through August 2024. And then in August 2024, you began working at Uber Eats.
Okay, it looks like what I wrote.
Okay. And I want to make her 2 discovery responses a collective exhibit.
All right.
If we can pass
those the ones in her.
Yes, pass those copies out.
I'll just hand that to the.
So, Ms. Brown, we've talked a lot about your employment or lack thereof over the last year and a half.
Hmm.
You signed a lease to move in with your grandmother.
Mhm.
And you moved in, you said June 3rd of this year?
Yes.
Okay. How old is your grandmother?
She just turned 81.
81. Okay. And you said there's some memory issues.
A couple.
Okay. And is this the type of memory issues that are going to progressively get worse?
I'm going to need to speak with her doctors about that. I don't want to say something and then be wrong.
But it's to the point that she needs a living caretaker?
Yes, it's also in addition to her eyesight as well. It's hard for her to see around the kitchen, drive herself.
Do you think that you would have sufficient time to care for the children full time while caring for another individual as your full time employment?
Yes.
Okay. You mentioned to the court that when you moved back to Indiana, you've been going back and forth week to week. Is that correct?
Yeah, every Friday I've been driving down here to the Cheatham County Sheriff's Office to pick up the girls or drop them off.
But that was after you left the children with Mr. Brown for 3.5 weeks before you started exercising time with them in Indiana, correct?
Yes. Mr. Brown had actually, I had reached out to him requesting a Zoom call with the girls, and I had received a response back, and he's like, well, you never gave me any kind of notification that you were leaving. And I'd asked him, I was like, what do you mean? I thought you were served on the 21st. And his response was that he was not going to help me with the motion.
21st of what month?
I would have to check.
What month did you file your petition?
Would have been June. No, I filed in May. I'm sorry.
Okay. All right. Sorry to interrupt. I just want to make sure we're on the same timeline. So you filed your petition and immediately moved to Indiana.
I filed the petition and I had called the courthouse the next day, and I was told that it had been sent over to the sheriff's.
I'm going to object to the answer at this point. That's not the question that was asked, and we're also veering into hearsay.
Sustain the objection. Just answer the question that you're asked, please.
So immediately after filing the petition, you moved to Indiana.
I drove up that night and I called the next morning to see if they had, if it had gone through. I had received the impression that the order was signed, and that we had a
Can you
court
provide
date.
a yes or no answer to my question before you give an explanation? Immediately after filing the petition, you moved to Indiana.
No. There is a little bit of time there. The lease doesn't start until the 3rd, so it wasn't until a couple of days before we came to court that I moved in with my grandma officially.
Immediately after filing the petition, did you drive to Indiana?
Yes.
Did you stay with family in Indiana?
Yes.
Did you take the children with you?
No.
They stayed with Mr. Brown, correct?
Yes.
From the day school got out?
It was, I believe it was the day school got out.
And then did you see them when you were in Tennessee for court on June 4th?
I thought we had court June 5th.
Court on June 5th. Did you see them in Tennessee on June 4th?
Yes. When I got down to Tennessee, I checked with the courthouse, and that's when I became aware that my order had been denied. And so was the request that they had go with Mr. Brown. So when I became aware of that, I contacted Mr. Brown in order to exercise a couple of days of parenting time.
And then after court, did you leave the children with Mr. Brown and go back to Indiana?
Yeah, I believe they stayed with Mr. Brown that week.
Okay. So would June 12th be around the first time you started exercising parenting time with the children in Indiana? Would it be the week after court?
Yeah.
Okay. So between school getting out and the week after the May 5th court date was the first time you took the children to Indiana with you since you filed the petition?
Yeah.
The text message that you showed us earlier about asking Mr. Brown for the medication, that was on Saturday, June 13th, after you had taken the children back to Indiana. So you had moved to Indiana at this point, and you were taking the children several states away, correct?
Mm-hmm.
And you didn't check to see if necessary medication was packed prior to leaving the state with the children?
We were, I'm not sure quite how far down the road we were. No, usually with the exchanges, we don't talk a ton. A lot of times I will hand the medication to Mr. Brown. Sometimes he just hands it to the girls or he puts it in their backpack, and that's how I get the medication. So when I had texted him, I had assumed that he would have brought the medication. It's not something that I have been very excited to bring up at exchanges because I'm not trying to argue in front of our daughters. So I communicated, please bring the medication. The medication was not provided.
So you asked him ahead of time to bring the medication, but you didn't look to see if he packed it.
No, I did not.
Let's talk about this medication. When was Clara first prescribed this medication?
It's been about a year.
Okay. Was this supposed to be the only solution, or was she supposed to take additional appointments or tests or see anyone else?
No, she had initially she was going to be on it. I don't remember if there was an exact determinate amount of time that she was going to be on it. I just knew that the doctor wanted her to be on it for at least multiple months to see if there was any kind of growth. She was given a referral to Vanderbilt, and I believe that one had lapsed. I had spoken to Mr. Brown about that. I don't recall ever getting any kind of a response, and I'm not sure if that's why I didn't schedule or what, but I ended up having to call the pediatrician again to get another referral. And again, that was right before the lease. And we can go ahead and get that scheduled if we want to do it here, or if the girls end up coming up to Indiana with me, I can get that scheduled up there.
So the medication, she's supposed to take the medication, but get a referral and see a specialist over this issue. And you've still not taken her to see that specialist, correct?
Neither of us have taken her to see the specialist.
But you have not taken her to see the specialist, yes or no?
No.
Has she lost any weight?
It's not that she has lost weight, it's that she's not gaining at a very fast rate.
Have you taken her back to the pediatrician in the last 6 months to discuss the lack of weight gain?
Yeah, that was, I don't recall her exact appointment date, but that's when we got I had them put the referral back out for Vanderbilt. I would have to check their records to get those exact dates.
You mentioned some hair tangling and some teeth not being brushed. Let's
Yeah.
talk about the hair tangling first. Have you taken any photographs or presented any proof today of that?
I hadn't. I really wished I had, though. But
The not brushing their teeth for an entire week.
yeah,
Have you taken them to the dentist about this issue?
yes.
Have they had extensive issues at the dentist?
Clara has had to have several teeth pulled.
Do you have any proof of that today?
Not with me today. Other than if you look in Clara's mouth, so you can see the gaps.
But she's with you a sufficient amount of time as well, correct?
Sorry?
She's with you a sufficient amount of time as well, correct?
Yes.
Has any pediatric dentist told you that her dental issues are, or has, do you, let me try that question. Has Mr. Brown ever told you that he does not brush the children's teeth for a week at a time?
No, I believe he is denied it on several occasions. But when I speak with the girls tell me that they're not brushing their teeth, and you smell their breath when they get home, and it's pretty evident stuff's not getting brushed.
Have the girls ever told? Do you ever ask the children to do something and they don't do it?
Yeah.
Does that make you a bad parent?
I think.
No, just yes or no, please answer my question. Asking the children to do something and they not do it, does that make you a bad parent?
No.
If you want to provide an explanation, you can.
Okay. I don't think that makes you a bad parent, but when you know that your child is supposed to be doing something, or you are supposed to be encouraging some kind of behavior or habit, especially when it comes to health and hygiene, and if they're not doing it and you're aware they're not doing it, are you not wrong to not like encourage them to do that? Like if you tell a child to brush their teeth and they say, no, I'm not brushing my teeth, would you not then like maybe take the tablet away or something?
Are you at Mr. Brown's house? Have you ever seen him tell the children to do something?
No, I haven't. No? That's why I'm confused. I don't understand. I don't have an understanding on why a parent can't get their children to brush their teeth.
Do you think it would have any negative impact on the children to live several states away from their father?
Actually, I believe it might have a impact in the better for their education throughout the school year. When they're with Mr. Brown throughout his weekends, there is not much of a schedule. There's no consistency. They stay up however late they want. They're on their tablets for however long they want. It's whatever they can do to kind of like just be placated.
And you said that was on the weekends?
During the school year, he has them every other weekend from Thursday evening to Sunday evening. And so when they're not on any kind of a schedule and he's not doing he didn't do anything from the speech therapist, or if he's not doing any homework with them, they're not having sleep schedules, they're not brushing their teeth, they're not bathing. It takes me several days to get them back in check by the time they get home, trying to get them on a regular sleep schedule, waking up to where they're not grumpy, eating normally. Like it takes me several days just to get them back into the swing of things. So if I'm sending them to Mr. Brown's every other week, and then he's counterintuitive in the way that he's parenting them or spending his time with them, then I got to spend several days getting them back on track. If we don't have that gap every other week, and if their education and their schedule is consistent throughout the school year, maybe that might be a little bit better for them.
So you think it would be better for them to go the majority of the school year without having parenting time with their father?
If their father was expressing his parenting time in a healthy way, like why am I having arguments over whether or not my children are bathed? They're little girls. One's about ready to start menstruating. Bathing should not be this big of a problem.
Has Mr. Brown ever told you he does not bathe the children?
No, but when they come home and they say for the entirety of the time that they've been over there that they have not bathed, and it's not just like one off here and there, it's consistently. Yeah, I believe my therapist had every right to call child services.
And so it's your request that based on your inability to secure housing, your inability to secure employment, and Mr. Brown's inability to properly parent, that you should move several hours and several states away with the children and limit access to them during the school year.
I believe that it would be in the best interest of the girls to have two parents who would actually work together for them rather than out of spite for the other person. Is a perfect world. But at the moment, I believe that they should be with the person that, I mean, we're borderline negligent on some of this stuff. And I don't understand how I can sit here and continue to watch this and say, yes, I'm completely comfortable with Mr. Brown taking these girls.
Have you ever filed a petition to modify the parenting plan since it was put in place?
That's what
Before
we're
you're
doing here.
requesting to move the children to Indiana. You have listed numerous issues today that you have with Mr. Brown's parenting, correct?
Right.
Over the last 3 years, two and a half, 3 years. Have you ever filed a petition to modify the parenting plan?
I had not. Coming back into this courtroom again was a major struggle.
So these issues with Mr. Brown's parenting abilities did not raise enough concern with you to file a petition to modify the parenting plan until you wanted to move to Indiana?
No, ma'am. Well, yes and no, I guess. I didn't file another petition. I didn't want to file anything in this courtroom. I didn't want to be back in here. But it's kind of at the point where I knew I needed to file something. I knew that though things had been reported to child services, it didn't feel like, it felt like my children were getting let down. So I knew eventually I was going to have to come in here. I feel like the eviction is what kind of like put my feet to the fire and got me back in this room.
That's all my questions for this witness.
All right, thank you, ma'am. You may step down. Ms. Brown, do you have any other witnesses you intend to call? Other than the children that you had suggested?
Only if you wish to hear from them.
All right. You may step down and have a seat at this table.
Your Honor, I do have just a quick procedural question. The individual who is watching the 2 children today does need to be in Nashville for a doctor's appointment. Is he fine to take the children with him, or do you want the children made available today?
I'm not going to have the children come in as witnesses in this situation. This is an emergency petition to allow for relocation. And I don't think that the children at 6 and 11 should be put through having to testify. Ms. Brown has testified how traumatic it is for her to come into the courtroom. Why would we want to put those children through the same situation? Their preferences about who they want to live with is not an issue because this is only a petition to relocate. It's not a petition to modify.
Is it fine if I let him know that he can leave with the children?
Well, let me indicate to you right now, I do not find that there is a basis for an emergency relocation permission of these children. Instead, what I intend to do is to appoint a guardian ad litem. I think it's important for the children to have someone advocating on their behalf. And for that reason, I'm going to appoint Ms. Doris Salinas, who is a local attorney, to serve as the guardian ad litem. I want Ms. Salinas to have an opportunity to get involved in this case as quickly as possible. And I'm going to suspend this hearing and reset it for July 27th to allow Ms. Salinas, if it's possible for her to be involved in this case.
I do not have any child care that week.
I'm sorry, repeat
I
that.
do not have any child care that week. The 1 week daycare closes.
July 22nd.
Mr. Brown will be in Indiana working on a music festival that day.
In Indiana?
Annual charity music festival.
You gotta be kidding. You're going to be in Indiana?
Everybody is aware that both of the grandparents, both sides of the extended family.
Maybe he should move to Indiana. It'll solve a lot of problems. Well, I have July the 16th. Wait a minute. I'm sorry.
I won't be here.
That was a criminal trial that I had said.
think I have something in front of you on the 13th.
What?
I think I have something in front of you on the 13th.
What Thursday? This Thursday?
You said the 13th.
Oh, yes, yeah, that's
next
next
Monday.
week.
I'm leaving Friday and I'll be out of town for a week.
So you're going to be out of town, leaving town when?
The 10th,
When?
this Friday. My first day back will be on Friday the 17th. I can attempt to find alternate childcare on the 27th because I do want this to be readdressed before school starts. And looking at the Cheatham County calendar, August 7th is the first day of half day of school. August 10th, Monday is the first full day.
Well, I mean, I've given you all my available days, and all of you have some issue. I have available the 13th.
Would it be
Which
possible for me to participate by Zoom on the 27th?
Yeah, we can allow you to participate by Zoom. Is that the day you said you have no childcare?
I do. That's correct. I can.
I can do Zoom too.
I have a younger neighbor who can be in the home and help.
Well, we can reset it for the 27th. I just want to get Ms. Salinas involved in it to give her an opportunity to speak to the children and talk with them as quickly as possible before we then reconsider what the situation should be. I am simply on an emergency basis. I'm not granting the request to relocate, but the relocation itself would necessarily be considered by the court again on the 27th after the guardian ad litem has an opportunity to meet with the children. I'm concerned about your lack of stability, your lack of a job. I know this situation with your grandmother is by you considered to be a job, but what I'm hearing from your testimony so far has been a considerable amount of instability in your housing, instability in your work, and there's a history in this situation. And I know you have mental health issues that have been prevalent in this case for many years. So I'd like to get the guardian ad litem involved and have their input before we make a final decision on these things. All right. Then this case will be reset for the 27th at 9 o'clock.
Do you want me to draw an order?
Yes, but I'm going to have the clerk go ahead and notify Ms. Salinas. She may reach out to both of you to arrange to meet with the children, depending on where they are. Ms. Roberts and Ms. Stevens, you have the last case, I think, then, is that correct?
Yes, Your Honor.
And we're going to break for lunch, but any idea of the length of time that you're expecting? Ms. Stevens has stepped out.
Sorry, Judge.
Your Honor, this is a divorce matter that was filed. Ms. Stevens filed it on behalf of her client. I filed a response. We both have pendente light matters. There's an underlying criminal matter against Ms. Stevens'
Ms. Stevens' client, Judge.
client. So,
Thank you.
yeah, no, not against her. Ms. Stevens' client on her side that there's her client has been charged with aggravated domestic assault. On one note, before you break for lunch, I have filed today an order of protection. There's currently bond conditions in effect, but given the nature of the criminal proceedings, I did go forward and file an order of protection. Because there's bond conditions, I'm not necessarily seeking an ex parte order at this point in time, but I do want to get that set within a reasonable amount of time. And the reason I bring that up at this juncture is that I know Your Honor's given the dates to do it, and there's going to be some testimony, I assume, that's going to go up today. So I didn't know whether or not, you had a preference to go on and set the order of protection hearing for one of your July dates that are remaining, or whether you're okay with us maybe getting an August date. I don't know.
I don't care. I mean, whatever is your preference.
Okay.
If it's an order of protection that needs to be heard today, then we'll.
It's not. It's not. We're not seeking because there are bond conditions. If there's not an emergent necessity to get an ex parte order at this point in time. So we just need to set it. I told Ms. Stevens we would check and just get a mutually
Well,
convenient.
y'all
date.
talk amongst yourselves and figure out which day. I don't care. I've given out the days that the remaining days I have for this month are Thursday, the 9th,
and
the 13th on Monday, and the 27th. Is that correct?
Well, given the fact that the 9th is short, I'm here on the 9th, but I don't know if that's too short a notice for council. And then the 13th, I have that contested hearing and I have to leave early. So I wouldn't want to have everybody come and then us not get to it. So.
Well, Judge, the 13th and 27th, I'm unavailable, and the 9th, I have a Zoom hearing at 09.
I don't mind doing I think August 10th and the 24th are the next available dates.
And I'm in
Who do y'all have coming in? Okay. I guess I would have to get permission to see if he would hear it. Okay. Okay. Well, we'll work on it. I just wanted to let you know that was the situation, that we do have that order of protection, but it's not for hearing today. It was just filed.
Okay. So what we have for hearing today are the motions that you, motion for pending light support, motion for possession of the marital residence, division of marital debt. Is that correct?
Yes, Your Honor.
Okay. Are there children involved?
No, Your Honor, there's not children. My client will soon be 76 in September. Mrs. Gutzman is I believe she's 70, 71, both retired. There was a incident. There's bond conditions. There's a no contact order where the wife can have no contact. So from my standpoint, I filed my motions just as a auxiliary matter. I want my client to be granted possession of the home, which again, based on the testimony, and then on the division of marital debts, the only thing I'm requesting in that respect is that he's going to maintain all of the household expenses. There's a mortgage, utilities, taxes, insurance, maintenance, upkeep, things such as that. And then we just want to reserve the issue of any credit that he might get for that for the final hearing, because he is maintaining all of those expenses. So that's the sum and substance of my request in my petition on why I'm filing my motions. I think council, they're seeking some monetary award from my client that is contested.
All right. Well, we will stand in recess for lunch until 1 o'clock.
Thank you, Your Honor.
All rise.
Will be necessary.
Court stands in recess till 1.
Are those dates? I can do. Oh, actually, I can't do any ones in the court. And obviously, I'm not going to be in Stewart.
These were just the days that I have they're not necessarily all the dates that Rhonda has. These were the dates that I already had things scheduled over here. And I already had something on August 10th in front of Judge Wallace and the 24th. I just didn't have anything on the 5th, and I don't know what else.
Push it to the 24th because I don't have anything on that day.
The 24th, that's fine with me. Hey, can we do that order of protection on the 24th? I have to be here on another matter. August 24th is a date that I had down. Is that a Wallace date? Oh. She may, when I said that may be something, I asked Judge to send me all my dates. Okay. Hey, you sent me August 24th as a date in Cheatham. That's not a date they have. What do you have down on that day?
That's justice. I just see a date.
Oh, that's the justice, but that's in Charlotte. That's Judge Turnbow hearing it in Charlotte. Yeah. That
okay, I didn't know it was in Charlotte.
Justice is a Cheatham case, but we're hearing it in Charlotte with Judge Turnbow said especially in Charlotte. So that's not a date.
Okay, I will fix that on my
Yeah,
calendar.
put that in Charlotte.
Yeah, it was just
We know where Miss Stevens is.
No, you're right
I'm
there.
so sorry, Judge.
You ain't got something.
Your Honor, right before we broke for recess, I think it might help the situation if you would just grant me 5 minutes with my clients and we might be able to.
I don't have any
You
objection.
more than 5 minutes if you think it would be helpful.
Yes, Judge, it may be, I'm not sure. I tried to contact my client during our recess. It
Well,
was-
why don't I step off and you all send word to me and I will come back if you either can't settle it or if you can make an announcement.
Yes, Your Honor.
All rise.
I think it's okay. He unzipped. Unzipped his robe. I think it's okay to sit. Doing okay. Everybody's miserable, so I'm good. So I'm good. That's why I tell people from peace and harmony with all the earth. I'll be working at Walmart, I guess. I've got a son who's he'll be 23 in January. He just graduated with his MBA from UT in May. So
MBA at age 20.
yeah, he's just trying. He went on after he graduated from college. He wasn't ready to adult yet, so then he went and did a intensive 18-month program for his MBA. So if he could find a job where he could duck hunt and play golf, he'd be a happy guy.
Feels good. Yeah. I froze to death here earlier.
Huh?
About froze to death here.
Well, that was what I said. If I'm cold, I know everybody else has to be because I am hot-natured. And if I, what she's talking about is right. She was just agreeing to her son, just to help her get through. He suddenly wanted to know. He says, "Well, he just agreed to pay some amount of money, $600, just to get her through." And I said, "Well," I said, "he's the victim of domestic abuse. If it was the other way around, and he was the woman, she was the man, probably he wouldn't be asking for her to pay it so good." And I said, "You got the expense statement. It's not just you. Did she tell you she was getting money from her mother?" And she goes, "What are you talking about?" I said, "Well, I've encouraged my client to call Adult Protective Services in Florida to report that they may be mismanaging her mother's money." And I said, on top of that, and then I showed her the pictures. I said, "This is not the first incident of domestic abuse." And I said, "Look, bottom line is they're going to have to decide what they have to do with the house. If he wants it, he's going to have to buy her out. I mean, I wished I could argue something different where they're going to sell it. And then they're going to split the proceeds." I said, "This is about, other than that, that's about all there is." And she goes, "Well, let me talk." She was flabbergasted. And she says, "Well, this is why I don't do domestic work anymore." She said, "The reason I'm representing her is because of that criminal case. She's representing her a criminal case." And she said, "I'm going to talk to her." So when we walked out, she had already left to go to lunch. Your wife had. So she was waiting. She said, "Well, agreement, Your Honor, what we've got is we're going to work on getting the order protection set, but on a temporary division. My client is going to be awarded sole and inclusive possession of marital residence. He is going to be responsible for paying all of the debts associated, any expenses associated with the marital residence, which includes but not limited to the mortgage. There was a couple of utilities that the wife was paying, but he's assuming responsibility for paying that, taxes, insurance, upkeep. And he is going to be done with that, with the reservation of any that we still have the right to come in and ask for an offset for those payments at the ultimate final hearing on this matter if we're not able to resolve it. The parties have a certificate of deposit that matured in June that is, and that is going to be cashed out. My client's going to leave and go to the bank here in just a minute, cash that out and bring a cashier's check for half of that money. And he's going to, and then we're going to exchange that so that the wife can have that, and that is going to be a partial division of marital assets, Your Honor. So he will have freedom to do what he wants with his half. She will be free to do what she wants with her half. If they have to use it for expenses, that they have every right to spend that money any way they want to do it. We're going to contact a local realtor to go out and to look at the home to hopefully give us an opinion of value so that we can move this matter. That's the party's major asset, is the marital residence. There's some significant repairs that need to be done, remodeling, things like that need to be done to the home. So we want to get an opinion of value so that if my client has the option and has the availability to buy out his wife's interest, then certainly we will work towards that. If not, then we're going to go in and get it listed for sale. And so this is going to be a temporary agreement, Your Honor. We are not foreclosed from coming back in for any other temporary relief that is necessary once we get all of these things done. But this just basically puts a Band-Aid on the situation. There's a criminal matter pending, and of course that precludes, it assists the wife from having to get on the witness stand and invoke her Fifth Amendment privilege at this point in time with the criminal charges pending. Hopefully it will de-escalate some of the tension in this matter as we move towards getting these parties divorced. And
Ms. Stevens, you agree with all of those terms?
yes,
Any reason to have your clients acknowledge it on the record?
yes, Your Honor, if we could you just stand up and raise, both of y'all stand up and raise your
You'll
right
both
hands,
stand
please.
and raise your right hand.
State your name for the record, please, sir.
Steve Getzman.
And Mr. Gatsman, you've heard what I have explained to the court today, and that's your agreement.
Yes.
Please state your name for the record, ma'am. Beverly Gatsman. Yes, ma'am. Put your hand down. Did you hear the announcement that was made? Yes. Do you agree with that?
Well, I'm very happy that the two of you could come to a reasonable agreement, at least on a temporary basis, and hopefully that'll serve as a basis for you to resolve this entirely. So I'll be happy to do it. Who's drawing the order?
I'll draft the order and submit it to Ms. Stevens for her approval.
That concludes our business today. I don't know if you have anything on Thursday.
do.
I have criminal motions tomorrow. Y'all can have a seat if you want.
You sit down.
I have criminal motions tomorrow. We're going to move to the old courtroom because this air that blows constantly, as you can hear from my voice, I can hardly, this is blowing cold air from two directions. So we're going to see if we can get that fixed. Holly's got somebody coming to look at it, but we're going to move to the old courtroom tomorrow, and they're having to work at the new non-jury courtroom tomorrow too. And then Thursday, when we have Chancery, we'll probably still be there.
Good.
So that'll be.
I'm a traditionalist, Judge. Beautiful courtroom, but I like the old one.
I know, because you're one of the few people who can still be heard above all of the stuff that goes on inside that old courtroom. So
yeah, nobody's ever said that I'm quiet.
all right, then we stand adjourned. So.
Thank you, Your Honor.
Thank you, Judge.
All rise.
There's one thing I've never been accused of. I've been accused of a lot, but quiet is not one of them. I'm not the soft spoken. Okay, you run to the bank.
Yeah.
Okay.